went simply down quick, didn't it?
I trust you're not going to tell any stories about your siblings.
I don't intend to, Your Honor.
Okay.
I can if Your Honors would like me to, but I can't. I have 3 of them. I'm sure I can come up with something. Good morning, Your Honors, and may it please the court. My name is Ben Lewis, and I represent the appellant in this matter, Garry Lynn Pickett. If I may, at this time, I'd like to reserve 3 minutes for rebuttal.
3 minutes, yes, sir.
Your Honor, Mr. Pickett raises 2 issues for consideration of this court on this appeal. The first issue is whether the trial court erred in classifying property at 442 Shady Grove Road in Lincoln County, Tennessee as marital property and not as separate property. And secondly, whether the trial court erred in holding the husband in criminal contempt prior to the court's order becoming executable. The facts of this case are largely undisputed, which is a good thing because there is no transcript in this matter. A statement of the evidence was submitted for the court's consideration, but no court report or transcript exists. The pertinent facts as to the property are that husband purchased this property, it's a house in 17 acres, in February of 2012 for $150,000. He purchased that house in his name only, using funds from inherited property that he had sold. In November of 2013, he conveyed that property, or included his wife's name, his future wife's name, on the property with an undivided interest with rights of survivorship. That was in November of 2013. Approximately 3 months later, in February of 2014, they were married. So this house, it's undisputed that this house was originally owned by Mr. Pickett. Miss Pickett's name was added to it prior to the marriage, and then they got married approximately 3 months after that. From those facts alone, the trial court, from those facts, simply states that the property is marital property. That's the only conclusion that it raises. And it says that because the property was purchased and held as joint tenants with right of survivorship, that it is marital. However, the court does not take into account the fact that this property was owned by these parties as tenants in common prior to the marriage. Under Tennessee law, marital property is any and all real or personal property, tangible or intangible, that's acquired by these parties during their marriage. Separate property includes real property owned by the parties prior to the marriage, which includes this property. So it's our position that the property itself, when it was owned by these parties prior to marriage, has to be, under the definitions for marital property in Tennessee law, has to be considered separate property to start because it was owned by both of them prior to the marriage. The court goes on to say in a later portion of the ruling, and also in the ruling on the petitioner's or the appellant's motion to alter or amend, that the property was transmuted and that Mr. Pickett admitted to transmutation in his deposition and subsequently in his motion. I would submit to this court that Mr. Pickett cannot admit to transmutation. These courts have long held that any admission by a party as to a legal conclusion or a legal outcome is not binding on that party. That's for the court to take the facts and apply them to the law and make that determination. What the court lacks here is that if it was going to reach the conclusion that transmutation had occurred, the court would have to go through a findings of fact and conclusions of law portion of its order to say, here's how I reached the conclusion that transmutation occurred, if in fact the property is separate as we argue.
In this case, the trial court ended up ordering the sale of the home and the proceeds to be split equally by the parties, correct?
Yes, Your Honor.
So why does it matter whether he got there by transmutation or whether he got there by the previous deed arrangement? I mean, in any way you look at it, the parties contemplated half to each party.
Potentially, Your Honor. In a partition action, there's at least the argument that in partitioning the property and making a division of the proceeds, that the court could have considered in doing so an equitable division and put back in place Mr. Pickett the $150,000 he put into the property. So I believe that rather than making what amounts to, if the transmutation has occurred, in my opinion, if the transmutation has occurred, the court has a much more constrained ability to give Mr. Pickett his $150 back because he's made it at that point a gift to the marriage. The whole property itself is owned by both parties. If we take it back to tenants in common and they are required to go through a partition action, then in that situation, Mr. Pickett has a legitimate argument to be made that he could get back out what he put into the property, put him back in the place he was, and then they could then split the equity after that's done. Because the facts as they are found by the court, and they're not challenged on appeal, is that Ms. Pickett admits she didn't provide any income or any money to purchase the property. She admits that she didn't contribute to any of the expenses. She admits she didn't contribute to any of the upkeep. She admits she didn't contribute to any of the improvements to the property. Her own appraiser, who she brought to court, he testifies that the increase in value to that property from $150 to, he says, $445 at the time of trial, that was largely due solely to market forces and not to anything else.
And how long did they live there together?
They lived there from 2014 until their divorce, which was in 2024.
Okay.
So that would be approximately 9-10 years. They did not live there during the entirety of the divorce.
Right.
They separated, and I think Mr. Pickett maintained possession of the house for a period of time.
So they lived there together as a as the marital home.
That's correct.
And he, prior to the marriage, deeded her an interest in the property.
Correct.
But he wants his 150 back.
That is correct.
All
He
right.
wants credit for what he put into the house. And Your Honor, I would submit that these facts are not on the record, but certainly they could have been had the parties gone down the path of correctly arguing this and presenting these facts. But I think it's as reasonable to conclude that Mr. Pickett could have been doing this for the purpose of keeping it separate, in that he was saying, rather than wait 3 months and put my wife's name on it, I'm going to deed it now so that she owns it if I pass away, but if not, it's not our marital property or something of that nature. Those facts aren't there, but the court doesn't have the benefit of making assumptions necessarily from the facts. That's one assumption the court could reach, is that this was done intentionally to try to keep this property separate and deed it to her so she
I
could
prefer
get
not
it.
to make assumptions on facts that are not in the record.
Correct, but I think the only way we get to that it was the deeding to her prior to the marriage was a gift to the marriage is also an assumption based on the facts in the record. So either one of those two conclusions, in my opinion, requires this court or the trial court, based on what's in the record, to make some type of assumption as to the intentions of these parties when they did what they did, and including Ms. Pickett's name on the property prior to the marriage, because those facts just don't exist in the record. Had the parties been able to put those facts in, had the court asked for them, had the court said, well, what was the intention here, then the court could have gone down the path of a transmutation argument. And in doing so, the court would look at use of property as marital residence. Certainly that's a fact, Your Honor, for purposes of the transmutation analysis. Looking at the ongoing maintenance and management by both parties, which would weigh in favor of it not being a marital home or transmuted, because Ms. Pickett contributed nothing to the maintenance and the management, which she admits. Placing title and joint ownership, which is a tricky one, because yes, that occurred, but it didn't occur during the marriage, it occurred prior to the marriage. And using the credit of a non-owner spouse to improve the property doesn't apply here because the property was paid for. So some of those facts would weigh in favor, some would weigh against, but that's not the consideration that the court entered into in this situation with the trial, or the trial court did not enter into that analysis. So from this record, it's at least arguable that transmutation did not occur, but the court doesn't go down that path. So it's our position that the court didn't go down the path of transmutation. The property clearly, from a legal analysis, is separate property. It's owned prior to the marriage, and therefore, without that analysis having taken place for transmutation, it should have remained separate property. If these parties wanted to, at a later date, to partition that property, to divide it up, to figure out who gets what from it, they could have done so. But the court should have allowed them to remain, and I go through the analysis as to why it was tenants in common with right of survivorship, that they should have allowed them to maintain as tenants in common with right of survivorship, and they can do with that property what they want afterwards. And it'd be my position that at a partition action, Mr. Pickett's argument of 150 coming back to him off the top is a very good one. The second issue that I raised in my appeal is a very narrow one, and that relates to a motion for contempt filed by Ms. Pickett after the divorce decree was entered on May 20th of 2024. Within about 2 weeks, on June 6th of 2024, Ms. Pickett, through her counsel, filed a motion for criminal contempt against Mr. Pickett on several grounds. A hearing was held on June 18th of 2024, and an order was entered on June 21st, 2024, finding him in contempt on all of those allegations. Tennessee Rules of Civil Procedure 62.01 provides that no execution shall issue upon a judgment, nor shall proceedings be taken for its enforcement until the expiration of 30 days after its entry. Within 30 days after the entry of the final decree of divorce, Mr. Pickett filed a Rule 59.04 motion to alter amend, which further extends out that time for purposes of execution or taking proceedings for enforcement.
In this case, though, the order specifically said, of course, that they're to agree on a realtor within 15 days. So that provision of the court's order obviously comes before the 30-day
It does.
time. So what is your position on how that impacts the finality?
I think there's two aspects of that. One is I don't think the court should have done that in the first place, of saying that within 15 days the parties are ordered to agree on something. I think as to finality of that order, I don't think it affects the finality, because I also don't think the court can order someone to agree on something. If the parties disagree over who they choose, then all that does is bring it back to the court to decide who that realtor is going to be. I don't see how Mr. Pickett can be held in contempt for refusing to agree, because that implies that the other side didn't agree to his choice. So these parties not agreeing to it, I think certainly it's an issue. I don't think the court should have done it, but it's not necessarily something that is enforceable when it comes to the finality of the order, because it's like an agreement to agree when you enter into a contract. That affects the ability for the contract to be enforceable, because you can't agree to later agree on something. And this court essentially forced them to agree on something down the road, which it didn't really have the authority to do. I would submit to your honors, because again, if these parties don't agree, they don't agree. Then it comes back to this court for some type of determination, or to appoint a realtor. But as to the finality of the decision regarding selling the home, I don't think it affects that in and of itself. But as to the finding of criminal contempt, Your Honor, ultimately Mr. Pickett was held in criminal contempt. He was ordered, an order was entered approximately 2 weeks after that, and then he was also ordered to pay attorney's fees for Ms. Pickett. It's our position that under the plain rules of civil procedure that Mr. Pickett was not, that no enforcement proceedings against him were permitted to take place at that time, and that order for contempt, including the award of attorney's fees, should be stricken and vacated. Thank you, Your Honors.
Thank you,
I'll reserve the rest
Mr.
of my time.
Lewis. We'll now hear from the appellee. Good morning.
Good morning. I'm Pat Fraley, Your Honors. I'm a member of the Lincoln County Bar, and I'm here representing Mrs. Pickett in this particular case. As to the first issue, I would mention to you that the statement of facts states that Mr. Pickett agreed that his money had been transmuted, and what Mr. Lewis left out, and incidentally he was not present for the trial, what he left out is that Mrs. Pickett's testimony was that she put $40,000 into this property, but that she agreed that that had been transmuted and did not make it an issue. And one reason that she agreed to it was because I told her to, and I explained to her about transmutation. And I think that we probably would not be here today if someone had taken a firm hand to Mr. Pickett, but that did not happen. Now, the parties agreed, not only in court, but they agreed Mr. Pickett agreed in his deposition that this was marital property. He agreed in his asset and liability sheet, he called it joint property. Ms. Pickett called it joint property. It was both agreed at trial, as is in the statement of the evidence that in my brief, that the property needed to be sold. However, knowing that you all would probably have some questions, I did research the cases that Mr. Lewis had put in his brief. And one of them is a 2002 case, that's Langschmidt. One of them, Snodgrass, is a 2009. Keat is a 2007, and Batson is like a 1988 or something. The Langschmidt case involves IRAs. The Snodgrass case involves 401ks, and the Keat case involves stock. All of these cases do address transmutation, and the thread that flows through these cases is that it is in fact the intent of the parties that the court should look at. And when you have both parties testifying that the funds placed into the purchase of the house, that the funds were transmuted, and they put it in all of the documents that are presented to the court pre-trial, I think that the intent is quite obvious. I apologize that I did not. I was probably very, very brief in my response to issue 1, and I shouldn't have been so brief, but at any rate, that's the way I saw it. And as to issue number 2, I do want to say one more thing, and I'm sure you'll correct me if I'm wrong about this, but TCA 66-107 relates to joint tenancy, and if I read it correctly, then the survivorship portion of that statute was abrogated. I can't even find the date that it happened, but it was quite some time ago. So I would emphasize to the court that Mr. Pickett's putting on the deed where he deeded to his fiancée and then 3 months later his wife, a right of survivorship would indicate to me further intent to create a transmutation of any funds that were placed into the property. Do I have any questions about issue 1? Okay. Issue 2 is a little bit more complicated, and this is the one about contempt. I pointed out to the court that I was quite entranced with the argument of the lawyers who were trying, I think, to address the issue of the recusal in the prior case, because in this particular case, Chancellor Cobb, who is wonderful, is in his 24th year, I believe, as Chancellor in the 17th Judicial District, was quite patient with Mr. Pickett, who refused to answer interrogatories, who we had to do a motion to compel. He had to be ordered to answer the interrogatories. He begrudgingly did so without signing them. He didn't sign his income and expense sheet. As a matter of fact, he did have to pay me a small fee required by the court to bring the motion to compel, which was ordered. He was ordered to do it on a certain date. He didn't do it. I think it was like 16 days later, and then it wasn't complete, which required us to, or it required me, to make the decision to take his deposition. And it was probably a good decision because in that deposition relating back to issue number 1, he did in fact admit that this was marital property, but he wanted to argue about the value that had been assigned to it. Back to the contempt issues, we had mediated. He had kicked the door in at the house and refused to repair it. She was still living there. They were living there. He had not repaired the HVAC. As of the date of the trial, I think it had been out of commission for a year. He had refused to do anything about the mold and mildew in the swimming pool. He had cut off her access to debit card to get food. At one point, he turned the water off to the house. He changed the locks, and that was within 30 days after the divorce, as was brought up in the motion for contempt, in addition to his not signing the contract for sale of the house. I know that you don't want me to go beyond what we have here, but I will tell you that the contract was only recently signed.
The contempt finding in this case, though, notwithstanding all of the other behavior that you've just outlined, the contempt finding in this case was based particularly on the refusal to agree on an agent to sell the house. Is that correct?
Yes.
So my question is, it seems like in the court's original order, the court said, try to agree on someone to sell the house, and if you can't, come back, and I'll give you all 3 names, and you can choose, or some sort of process. So why was contempt the appropriate remedy for that, as opposed to, I mean, if you would refuse to participate in the process, that is de facto not agreeing, so why wouldn't the remedy be to come back to the court and ask the court to name 3 realtors for them to choose from?
Well, there were other things that were brought up in the motion for contempt, Your Honor.
Well, that's my question. Is the contempt just on the failure to agree, or is
No,
it on other things?
It was not
Okay.
just on the failure to agree. That was only one of the issues. I want
Okay.
to say to you, though, that when that motion for contempt was filed, Mr. Pickett's lawyer was given plenty of notice of it, and he did not appear, nor did Mr. Pickett appear. So the chancellor signed the order, and Mr. Pickett abated in part. We had to bring 2 more motions for contempt, and we've had to bring several motions, as the file reveals. Any other questions?
Hearing none.
Thank you.
Thank you, Ms. Fraley.
Yes, Your Honor.
Mr. Lewis, your rebuttal.
Yes, Your Honor. Very briefly. As to a couple of issues that were raised, I did not represent Mr. Pickett. That's been stated during the underlying divorce. But I will state on his behalf that our case law is clear in this state that in making a division of marital property or determining classifications, determining values, that fault of parties cannot be considered in doing so. So I understand that maybe there was significant frustration on Ms. Fraley's part from Mr. Pickett. I wasn't present for any of that. But if that's true, it can't factor into the issue that I have raised in factor 1, which is that the classification was done incorrectly. As to the other issue raised regarding Mr. Pickett's deposition, I go back to the fact that if the question was asked of him, I was unable to find where the question regarding transmutation was contained in the record. The court, in making its statement of evidence, based off of the competing statements of evidence that we submitted to the court, Chancellor Cox made his own and entered an order on that. And in doing so, he has one line in there that says that Mr. Pickett admits to transmutation in his deposition, and then cites to just generally the deposition, not some specific citation to a page or a line, anything of that nature. The question is not asked so succinctly in the deposition. Maybe there is proof in there, but it doesn't get us back around to the issue of there's no finding of fact or conclusion of law as transmutation in this case. There's a conclusion of law, I suppose, but there's no facts supporting it. But even if that question was asked, if I asked a party during a deposition, did you transmute this property to marital property? If he or she answers yes, that doesn't get us to the conclusion, because a party can't admit to a legal conclusion, which that's what the transmutation is. It's based on fact, but the court has to make that conclusion based on those facts. So I did not find that in Mr. Pickett's deposition, and again, potentially facts that would lead to an analysis of transmutation are there, but not so succinctly as I transmuted property contained in that deposition. As to the contempt, Your Honors, I would agree with Ms. Fraley. There were several other issues of contempt aside from just the issue of selecting a realtor. But regardless, it doesn't change the fact that this all admittedly occurred well within the 30 days that this should have essentially been stayed during that period of time. So that's all I have, unless Your Honors have questions, but I appreciate your time today, and thank you for listening.
All right. Thank you, Mr. Lewis and Ms. Fraley, for your arguments. We'll take this matter under advisement. That concludes the morning docket.